Hey everybody, let's get started. This is a free Florida bar approved CLE. It's called Florida's fourth DCA, a year in review of significant opinions for the year 2020. My name's Colin O'Brien. I'll be doing the CLE. If you're watching this on Zoom, please go to the chat function to get a copy of the demonstrative that I'm going to go through. I think it's super helpful if you follow the demonstrative as I go through. There are hyperlinks to the cases that we're going to talk about. If you're watching this on the rebroadcast, please email wizard@floridadcawizard.com for a copy of the demonstrative. It's extremely helpful if you have a copy of the demonstrative while you go through the presentation. Okay, this is a free 2-credit hour Florida bar approved CLE. Probably around the 1 hour mark, we'll just take like a 5-minute break. But when you get to putting in your time on floridabar.org, you need this reference number here to get credit. This CLE is being conducted on Zoom and it's being recorded live. So just so you know, it's being recorded and it will be rebroadcasted. This CLE is being conducted by the Florida DCA Wizard, which is my for-profit company. My name's Colin O'Brien, and what the company does, it provides real-time case law updates of Florida appellate court decisions, little punchy bullet point summaries with a link to the case, so you don't have to read the 15 pages. You can see a top line and click on the link if you need to go further. So this CLE will cover significant opinions in the fourth DCA for the entire year 2020. There were over 700 opinions, and I reviewed them all. And I'm not talking about PCAs. I'm talking about written opinions with like language and cases and stuff. I read them all, and I went through my summaries, and I took out about 100 total. And clearly, it's not every case, but I grouped them into the subject areas you see here on your screen: premises liability, damages, torts, contracts. Category I put as fairness, some motions to suppress, social media category, criminal law, civil procedure, ton of sanctions decisions, some discovery decisions, some cases about jurisdiction. There were just some great quotes. Some of the judges write in a really neat way, and attorney's fees and costs, and then miscellaneous. We could spend 2 hours on one case. So the goal here is to give a broad brushstroke of a lot of subject areas. So there's something to take away for everyone. You have hyperlinks to the cases and you can draw your own conclusions and read deeper into the cases. But I'm taking significant issues that I see that could affect practitioners in certain areas. So the first set of cases are premises liability cases. And just so you know, you'll be seeing on the cases a judge. So I'm attributing the case to the trial court judge. It's not the appellate court judge. And then each case, like I said, has a hyperlink. And then the top screen here has a bullet point summary of every case that's in the slides to follow. So here are some premises liability cases. The first one is Abdad versus G4S Secure Solutions. It's the Judge Hayful case out of Palm Beach. This was the Pulse nightclub shooting. I don't really want to get into the facts of it, but basically the guy who went in and shot up the club was employed at the time by a private security company. He wasn't working for the security company on duty at Pulse, but he was working for the company at the time. He was employed at the time. And the company had knowledge of this guy saying really heinous things, like expressing a desire to commit acts of mass murder against members of the general public, particularly against members of the lesbian, gay, bisexual, and transgender community. He also repeatedly threatened his colleagues, and I'm quoting from the case, it's on your screen, claimed to be in league with the terrorist groups, Al-Qaeda, and so on and so forth. And the fourth DCA said, despite all that, despite the company that employed him knowing all that, they couldn't be liable to the people who got shot up at Pulse. It was kind of like a slippery slope analysis. I'm quoting from the case. Appellant's failure to provide any sort of spatial or temporal limits in the articulation of their concept of duty would essentially result in the security company being strictly liable and an absolute guarantor of the shooter's behavior while off duty at all times. Okay, next case is Off the Wall and Game Room versus Gabai. It's Judge Lopane out of Broward County. A child was dropped off at a trampoline park, and those waivers they make you sign, he just went ahead and signed it and said it was his parents. And then there was a lawsuit, and the game room wanted to compel arbitration. And the defense to that was, well, the kid signed it, and that's not fair because he's a minor. And the fourth DCA said, no, in Florida, a minor cannot use the infancy defense to avoid a contract where the minor procured the contract by fraud. Next case is Peterson versus Pollock. This is Judge Henning out of Broward County. This is one of the Parkland shooting cases. Not going to get into the facts. It's horrible to talk about, but I couldn't help but talk about these cases. There was a motion to dismiss by the deputy who was sued, and he claimed sovereign immunity, and the fourth DCA said, no, we're going to overcome sovereign immunity because, and I'm quoting from the case, the deputy acted in bad faith with malicious purpose or in a manner exhibiting wanton and willful disregard of human rights or safety. Next case, Medina versus Pollock, Judge Henning out of Broward again, another Parkland shooting case. And there were allegations against a Parkland campus security guard, and they were sufficient to withstand dismissal as well. And here the actions were alleged to have been a conscious and intentional indifference to the consequences of this security guard's actions, and that he knowingly and purposefully failed to call a code red. So these are, again, premises liability type cases. Another one about Parkland, the mental health facility that housed the defendant, Mr. Cruz, was sued because they had the guy and then he went out and did the shooting. Isn't it Henderson Mental Health Facility's fault? And the fourth DCA said, no, we can't hold Henderson Mental Health Facility liable for what happened at Parkland. They said a lot of things, but one of the things that stood out to me was holding that Henderson Mental Health Facility owed a legal duty to protect or warn students that attended the same school as one of its patients would not only undermine effective patient-therapist relationships, but it would also discourage mental health professionals from providing mental health services to students. Next case, Bryan versus Galley Made Marine Products. Judge Buchanan out of Okeechobee County. This may be important if you have business clients that have heavy foot traffic. Apparently, there was a guest on the property, and he got beaten up. He got knocked out for 17 seconds, and the premises, the business was sued, and the fourth DCA said, yeah, that one was not foreseeable. But then after the guy was on the ground, in between that, him being on the ground, he was continued to be taunted, bullied, and harassed by the guy who knocked him out. And so then the second attack, that was the premises fault. And the top line from this case is, a proprietor is under an ordinary duty of care to render aid to an invitee after he knows or has reason to know the invitee is ill or injured. So the guy's laying on the floor, they should have done something. Quoting from the case, record evidence existed that Tumokowis knew or had reason to know, I blew that name really bad, but anyway, knew or had reason to know that plaintiff was endangered or injured after the first attack, which rendered him unconscious for 17 minutes. And then after the second attack, which again rendered him unconscious, yet, this person took no action. So I think it's an important decision for your clients that have people heavy foot traffic. Salinas versus Whedon. It's Judge Bronis out of St. Lucie County, and a utility contractor was electrocuted on an electrical wire, and the fourth DCA said the homeowner could not be liable. because the wire was visible. And the top line from the case is a property owner is generally not liable for injuries sustained by an independent contractor or its employees while performing their work. So, and here, it was a little weird how this testimony came out, because apparently the person admitted that he saw the electrical lines above the palm trees, but he was electrocuted. In any event, they were visible, and the person who got electrocuted said he saw them. So the homeowner was not liable. Okay, on to some damages cases. Here are the bullet point summaries. And okay, so first case is P&G Trucking of Brandon Inc. versus Riverland Hedging and Tropping. There was a car accident that destroyed a tractor and a citrus topper. And this was about business interruption damages. And the fourth DCA said the time spent by Lindsay overseeing cleanup of the accident scene, figuring out compensation for damages, traveling for meetings with administrators relating to pre-existing contracts, and searching for a replacement operator, that's not business interruption damages. Quote, business interruption damages are generally only recoverable to compensate a business for its lost earnings, not to compensate for other potential loss, consequential losses. Moreover, and then quoting from the case, the 150 hours spent overseeing the cleanup, figuring out compensation for damages, traveling for meetings, and searching for a replacement operator was not an obvious consequence of the accident or reasonably foreseeable. That's a good business interruption damages case. Clark versus City of Pembroke Pines, Judge Hari out of Broward County. This was an inverse condemnation case. And so there was a trial where the city was verdict for a judgment for the city, no inverse condemnation. And the fourth DCA reversed that and said that the city put up these barriers that stopped Clark's use and enjoyment of his property. I'm quoting from the case. Clark could not utilize his truck, boat, and trailer anymore. And the barriers also disrupted some of the municipal services. It was mail, garbage, and emergency medical access. So this was inverse condemnation. The right-of-way was blocked. Next case, Picture It Sold Photography versus Bunkelman. It's Judge Small out of Palm Beach. And here, the fourth DCA reversed a denial of an injunction regarding a non-compete and non-solicitation agreement. This is a great case if you have a non-compete or a non-solicitation agreement. Either way, either to distinguish your facts or go with what happened here. And here, the trial court, quote, failed to properly apply the presumption of irreparable harm flowing from violations of the agreement, and improperly determined that evidence in support of fraudulent inducement affirmative defense precluded a temporary injunction. The contractor admitted that he continues to solicit employees and he continues to compete. So if you're trying to enforce a non-compete, you would try to get facts that align that would align your case with exactly what happens here, get an admission about what they're currently doing. Okay. Next case, Sapp versus Olivares. It's Judge Hari out of Broward County. And this was a punitive damages case. We're going to see this case again on disqualification, but basically a Publix driver was using a cell phone, and Judge Hari allowed for punitive damages, and Publix appealed, saying, basically taking issue with the factual basis for punitive damages. And the fourth DCA reaffirmed that a trial court, for the purposes of punitive damages and an interlocutory appeal, not an appeal down the road post-judgment, but one that, right in the middle of the case, a certiorari, petition for writ of certiorari, a trial court only has to find that there is a reasonable showing by evidence in the record or proffered by the claimant, which would provide a reasonable basis for recovery of such damages. I think based on the language in this case, you'd want your order, if you're getting punitive damages, to say exactly that, your proposed order, that I've, speaking for the judge, there is a reasonable showing, but that's all you need to do. In the interlocutory appeal, the court will not review whether there is a factual basis. Just the trial court just needs to say these basically magic words. Next case, Broward County versus CH2M Hill. Judge Tudor, there was a construction project at the Fort Lauderdale Hollywood International Airport, and there was a problem with the expectation interest damages. Quoting from the case, the trial court erred in computing the county's damages based on an improper measure of the county's expectation interest. Quoting from the case, the trial court computed damages based upon the county's expenditures in redesigning and reconstructing taxiway C in accordance with a completely different design. The new design was more expensive and more robust than the original design. The measure of damages for breaching a construction contract is the reasonable cost of construction and completion in accordance with the contract, if this is possible and does not involve unreasonable economic waste. So, good construction damages case. Next case, Cocon versus Auto Club Insurance Company of Florida. It's Judge Singal, who's now a United States District Court judge. There were damages to a pool deck surrounding structures due to a pool drain pipe leak. And the trial court found that there was an exclusion, a water damage exclusion that barred the claim, but the Fourth DCA said the water damage exclusion did not bar this claim. The exclusion plainly refers to naturally flowing water exerting pressure from outside of the plumbing system, not a leak from within the plumbing system itself. So insurance defense type cases, this is a good one regarding exclusion. A lot of construction in the case about language in the exclusion. Okay, on to some torts cases. Gilson versus Flagler Bank, Judge Kastronakis out of Palm Beach. And this was a case where the Fourth DCA found that the plaintiff properly stated a cause of action against the bank for aiding and abetting fraud and conspiracy to commit fraud. This is a hard case to win or to even state a cause of action for, that somehow a bank was in on like a bad act by someone using a bank account for improper purposes. But the Fourth DCA found that this was properly stated here. Quoting from the case, well, plaintiff succinctly alleged that, now I'm quoting from the case, the bank maneuvered critical funding to chariots so that it would appear solvent for as long as possible to attract investors. If you've ever looked this up, trying to sue a bank for a bank account being used for improper purposes and the bank being liable, very hard to do. This is a good example of how to properly connect the dots to withstand a motion to dismiss. Giat versus SCI Funeral Services, Judge Levinson out of Broward County. There was a dispute between a son and a widow over the burial wishes, and they needed to go back and remand with respect to the decedent's intention. Quoting from the case, because both parties dispute the decedent's wishes, each party should be allowed to present evidence to determine the decedent's wishes. Where a question of fact subject to proof is unanswered, an evidentiary hearing on the issue is required. Apparently the funeral services statute didn't apply. It was common law applied because, quote, the language of that statute does not apply to disputes between private parties as to the disposition of a decedent's body, and instead governs funeral homes and cemeteries. Next case is Williams versus Boyd Panacera Family Funeral Care, Judge Perlman out of Broward County. This is the impact rule, which you probably remember from like the bar exam. Do you need a physical impact? And there's like really horrific facts. A funeral home lost cremated remains of a miscarried baby. That's a horrible fact pattern, but the Fourth DCA found that the trial court properly granted summary judgment in favor of the funeral home. And quoting from the case, recovery was barred because the parents suffered no physical impact or physical manifestation of their emotional distress. and because the funeral home's conduct did not rise to the level of egregiousness required to support the intentional tort claims brought by the parents. And it's a good statement of the impact rule, quoting from the case. The impact rule, as applied in Florida, requires that before a plaintiff can recover damages for emotional distress caused by the negligence of another, the emotional distress suffered must flow from physical injuries the plaintiff sustained in impact. So the impact rule does not bar claims grounded on the tortfeasor's malice, great indifference, willful or wanton conduct or outrageous conduct. Really tough fact pattern, but that's the impact rule. Next case, Rehab Center at Hollywood Hills versus FP&L, Judge Hames, Broward County. Nursing home lost power after Hurricane Irma, and bad things happened. And FPL got sued because, like, hey, this nursing home lost power, isn't it your fault? And the fourth DCA said that FPL owes no common law duty to the general public to provide and maintain electrical service. So the motion to dismiss was granted and affirmed. And now I'm quoting from the case about this duty to the public by FPL. There must be an undertaking either voluntarily or for consideration. The complaint makes no allegation that FPL had any contractual obligation or that it had agreed to immediately provide power to the air conditioning units at the center. It alleges simply that FPL had a general duty to the public to maintain and operate its electrical grid. Some attorney's fees cases. I just got a note from someone saying they're having a problem logging in. Let me just see if I. Okay. All right, here are some attorney's fees cases. I'm going to go through some of these quickly because these are some discrete points that are helpful if you've ever litigated attorney's fees. So not giving a lot of treatment to a lot of the cases. Ramblewood East versus Rembaum, Judge Perlman out of Broward County. This is an interesting one, that expert testimony is not necessary to support an award of attorney's fees as compensatory damages where previously incurred attorney's fees are being sought in a separate contract against a client. So previously incurred attorney's fees, expert testimony is not necessary to support an award of attorney's fees as compensatory damages. Campos versus Arana Automobile, Auto Insurance and Multi-Services Agency Corp., Judge Rowe out of Palm Beach. Very simply, there is no requirement, and I'm quoting from the case, that a motion to tax costs be verified or accompanied by an affidavit. So cost motion at the end of the case, hey, I want to tax costs. It does not need to be verified or accompanied by an affidavit. Lubitz versus Shendon, Judge Burton out of Palm Beach. There, the fourth DCA affirmed the circuit court's denial of the law firm's motion to impose a charging lien. To get a charging lien, quote, the law firm must not only provide services, it must provide services resulting in a positive judgment, meaning like they have to do good work. I thought that was pretty interesting. And what it ended up happening is in defending the case, the client actually got fees for having to like deal with the charging lien. That was a very fascinating case to me. Okay, Skylink Jets versus Clucon, Judge Hames out of Broward County. This is in the weeds on prevailing party stuff, but it can matter for the purposes of triggering prevailing party fees on a contract or some other statute. And this person partially prevailed under count one. And that was not enough to be, quote, a prevailing party. And the fourth DCA said, we need to look at the circumstances of the case. And now I'm quoting from the case. Although Skylink prevailed on an issue of liability as to count one, it was an issue that was not seriously contested and thus was not a significant issue in the litigation. Clucon largely prevailed on the significant issue of damages by defeating most of Skylink's claim damages, making the case a wash. Very interesting. Even though they won partially on count one, it's not a prevailing party. So that's that case. Household Finance versus Williams, Judge Lazarus out of Broward County. This is about 57105 subsection 7. I put a quote there because a lot of us know like 57105 to be the sanction statute, but if you go to subsection 7, fees can be shifted pursuant to a contract. So this is about subsection 7, not about any other subsection, but it doesn't allow for what's called fees on fees, which if you've litigated attorney's fees, it's like the time spent dealing with the fees. And here, the fourth DCA said, a party may recover attorney's fees for time spent establishing entitlement to fees. However, a party cannot recover fees for time spent contesting or determining the amount of fees due under subsection 7. I'm not sure that's the same on other sections, but in any event, the fourth DCA said the trial court shall not award any fees for time allotted to the preparation or attendance for determining the amount of fees due to the borrower. So this is just pursuant to the contract. Office versus office, Judge Furrer out of Palm Beach, and there was a fee order that was not sufficiently detailed for appellate review. The fee order just said, yeah, you get fees. The former wife gets fees. And that wasn't enough. They reversed, saying that the trial court needed to make necessary factual findings to support a ruling on fees. So if you're going to give a judge proposed order, you should make some factual findings in it so that it gets upheld on appeal. Okay, next case is Roberts versus Third Palm. It's Judge Kaiser out of Palm Beach. And there, the trial court was required to hold an evidentiary hearing to allow a party to establish the reasonableness of costs as part of a judgment. Quoting from the case, the written order contains a citation that is relevant to the fees issue, but contains no elaboration as to why the court found no entitlement to costs. In other words, didn't say why there's no entitlement to costs. Got to have a hearing to determine whether costs are reasonable and should be part of the judgment. Okay, next case, Bentrim versus Bentrim, Judge Suskauer out of Palm Beach. And another insufficiently detailed fee order. The trial court erred by denying the motion for attorney's fees without making findings of fact within the subject order. Can't just say attorney's fees denied. There has to be an explanation as to why. Quoting from the case, it is critical that the trial court make specific findings of fact, either at the hearing or in the written judgment, supporting its determination of entitlement to an award of attorney's fees and the factors that justify the specific amount awarded. Vague findings present an obstacle to meaningful appellate review. So your proposed orders, you really want to be detailed, otherwise the appellate court will have an issue with it. Or if you're on the other side of a vague order, it seems like it's a good basis to appeal. Yontef versus Coppola, Judge Burton out of Palm Beach. The trial court erred in awarding attorney's fees based solely on the client's affidavit. So it was just the client's affidavit supporting attorney's fees. And the fourth DCA said, an award of attorney's fees is improper where it is not supported by the testimony of the attorney who performed the services. Kind of seems obvious, but here's a case that stands for the proposition that you need the attorney who did the services, not the client, to testify to the fees. Next up are some contracts cases. The first case is De Jure versus Coral Springs KGB. Judge Hames out of Broward County. This was a self-serving email that did not show consent to a settlement agreement. I think you probably dealt with opposing counsel or people who say, write an email. This confirms that we said this or that. And the fourth DCA dealt with that here. And so I took the language from the case, it's weird because the response, anyway, there were some typos that makes it hard to understand. But in any event, the self-serving email was, "This confirms we have resolved both of these matters for money, and the checks are waiting for you, and you will dismiss the cases." And the response was, "Yes, in one of the cases, but I told you I couldn't speak to the de jure plaintiff today." And the person who made the offer tried to enforce this exchange as a settlement agreement, and the fourth DCA said, "No, it doesn't matter that the lawyer came and picked up the check, and it doesn't matter that this person who said this confirmed signed it. De jure didn't sign it, and there was nothing saying that he spoke to actually spoke to de jure and got consent." So this sort of self-serving, this confirms, won't work unless you get a response that actually confirms it. Dale versus Schaub, it's Judge Kroom out of Indian River, and there was a proposal for settlement that was off by like a 0, which was pretty significant. And the party tried to, hey, fix it, and the trial court said no. And the fourth DCA said, well, the motion and affidavits clearly and unequivocally state that the plaintiff did not authorize his attorney to make an offer to settle his case for $10,000, and the attorney did not have the authority. So let him redo it and withdraw the $10,000 offer, off by a 0. So I guess you can mess up and a proposal for settlement and recall it. Okay. Merlin versus JM Family Enterprises. It's a Judge Singal case. He was out of Broward, who's now a United States District Court judge. And the lawsuit was precluded by an exculpatory clause in the employment agreement. And the waiver was not void for ambiguity and did not violate public policy. So there was an exculpatory clause, but this waiver was not void. And quoting from the case, "The waiver extends only to negligent conduct and does not infringe on the public policy prohibition of waiving liability for intentional torts, as the waiver only extends to injuries covered by workers' compensation." So if you're dealing with waivers, this would be a good case to look at to model your waiver over after some of the things you see in this case. Lugassi versus Lugassi, it's a Judge Levinson case out of Broward County. And there's a lot here, but the trial court, and I'm quoting from the case, forced the defendant, said, you need to, quote, sign contracts and personally guarantee the loans. But this was an ongoing deprivation of the freedom of contract because the orders required this brother in this dispute to cooperate by actually taking a pen and signing documents and doing things necessary to sign documents in the future to secure funding. So that was not right. That was overturned. And there's some interesting language here. It's an interesting philosophical concept, but the order imposed personal obligations upon the dissenting brother to which he objected. Not only was he forced to sign contracts and personally guarantee the loans, but the orders amount to an ongoing deprivation of freedom of contract. And then, they talk about the freedom of contract. The freedom of contract entails the freedom not to contract, except in the case of innkeepers, common carriers, and certain other public service companies. So I guess a court can't force people to sign documents. Stefanos versus Stefanos, Judge Fuhrer out of Broward County. This was a marital settlement agreement. The trial court erred in treating an agreement as a marital settlement agreement instead of as a postnuptial agreement. The parties executed the 1996 agreement while the marriage was intact and while the parties were not imminently considering divorce. Therefore, the agreement was a postnuptial agreement. Next case, PDK versus McConnell. It's Judge Kroom out of St. Lucie. And here, the parties' silence was not sufficient to show mutual assent. It was a shareholder dispute, and the trial court found that the shareholder did not forfeit his shares and was entitled to inspect corporate records, despite an affidavit from the defendant shareholder that the plaintiff shareholder, quote, refused to put more money into the corporation and was advised of the consequences should he refused. So the affidavit was saying, well, we told him what would happen and he never responded to that. Therefore, his silence meant he agreed. And the fourth DCA said, no, silence is not mutual assent. The gist of the affidavit, as well as appellant's pleadings, was that appellant had never voiced an objection to the forfeiture. That is not the same as mutual assent. Just because they didn't say, just because they were silent didn't mean they were agreeing with what you were saying. Wave Blast Water Sports versus UH Pompano, Judge Hames out of Broward County. And this was about leasehold, and that there was no specific end term. So what happens? The trial court did not err in granting summary judgment since the lease did not include a specific end term. And as such, the language of the lease renders the duration of the lease indefinite and terminable at will. So if there's no specific end term. And there's a great standard for determining whether a lease is clear and definite and certain essential terms. We're going to go on to some fairness cases. Just one moment here. Okay, on to some fairness cases. So this Graham case and this Publix case were on the same day. And sometimes it seems like the fourth DCA does that because they're kind of like the same issue, but opposite sides of the coin. And I'm still trying to get my head around these cases. But so Graham versus Randolph Construction Company Group, Judge Sasser out of Palm Beach. The appellants said that the trial court was biased in the commentary that the trial court made at the end of this bench trial. And the opinion doesn't give any detail as to what the comments were. But the opinion says a trial judge may form mental impressions and opinions during the course of a hearing, in the course of hearing evidence in a case. So a trial judge may form mental impressions and opinions during the course of hearing evidence in a case. They don't say what it was, and they just said that the trial court's comments pointed out by appellant arose after the court had heard argument and reviewed the contracts involved in this case or observed witness testimony. So I went to the trial court docket because I was interested in what the trial court said, and there's a couple 100-page transcript, but after argument and after evidence, this is the only thing I could pick out that the trial court might have said that the appellant had some issue with. I'm giving you some leeway, but the daughter already testified. You don't need to rehash it. She already has power of attorney. Why are we going to have her testify? It seems like that's something that courts do a lot. They want to move things along. We don't need to rehash this any longer. So I think that's what this person was complaining about. So go to the next case, the same day, Publix versus Olivares. This is that same case about the punitive damages that were upheld. The cell phone driver, Publix driver was on a cell phone and bad consequences. And so Publix was sued for punitive damages. And there, the fourth DCA said that Judge Hari should have recused himself because his comments tended to show disdain not only for Publix's legal position, but for the company's lack of a policy prohibiting cell phone use while driving. Thus, the judge exhibited a bias against Publix, and the judge should have disqualified himself. That's what the fourth DCA said the same day as this other case we just went over. In this Publix opinion, they didn't tell us what the judge said, so I went to the trial court docket and I looked at the motion to disqualify, and these were some of the things you see on the screen that were pointed out in that motion about what the trial court said. This was a colloquy during the hearing on punitive damages, And I didn't really see anything wrong with what the trial court said. So I'm trying to make sense of what the issue was. Publix doesn't have a policy about talking and driving. Are you going to change the policy at some point? It seems to me, going back to what the fourth DCA said the same day, a trial judge may form mental impressions and opinions during the course of hearing evidence in a case. Seems to me like the same thing. I don't know. I just have a hard time understanding, but maybe, if I had the appellate briefs, I could, really see what they were talking about. But those are two different sides of the same coin on commentary by judges. The next case is JDD Realty versus Arteza Homeowners Association. It's Judge Rowe out of Palm Beach, and there the circuit court erred in its nunc-pro-tunc order directing the clerk to issue a certificate of title for property. Nunc-pro-tunc, if you've ever dealt with an order like that, it's like, oh, there's a little change we need to make. Just nunc-pro-tunc it and change this and that. And this is a good case on, what the limits of nunc-pro-tunc are. A Scrivener's error type thing. Here's the quote from the case. While a nunc-pro-tunc order can correct the record to reflect actions previously taken, such an order cannot be used to enter an order that was wholly omitted or to change an existing order. So can't recreate stuff in nunc-pro-tunc. The Cove and Deerfield Beach versus RFast, Judge Rodriguez out of Broward County. And there was a commercial eviction. And if you've ever done eviction cases, there are a lot of deadlines. You have to put money in the registry, all that. And here, the eviction was upheld because of his default on payment. Even though the tenant mailed the rent payment to the clerk of court 2 days before the due date, the clerk deposited the payment into the registry 1 day after the due date. And the fourth DCA said, no, sorry, eviction. When a tenant fails to tender payment on or before the deadline, the court must issue a default for possession. This COVID-related administrative orders don't affect the result in this case. Like, don't blame it on COVID. You had to get the money there on time. You didn't. You might have mailed it 2 days before the due date, but you didn't get it there the same day. And you could have gone. If you read the case, the fourth DCA even says they could have gone down to the courthouse. And they say, we recognize the result is harsh. This is what the fourth DCA said, but eviction cases, there's little wiggle room at all on defaults on payment deadlines. Okay, some motions to suppress cases. State versus Fredericks, Judge Coleman out of Broward County. And here the trial court granted a motion to suppress that the fourth DCA reversed. And the search was okay because, quoting from the case, regardless of the fact that the driver was out of the vehicle's reach, the canine alert provided probable cause to search the vehicle, that is, made it reasonable to believe the vehicle contained evidence of the offense to arrest. I don't know if this impacted things, but the fourth DCA wrote it down, so I'm assuming this is a factor going forward in motions to suppress cases. They made it a point to point out that the officer, quote, would later testify this particular neighborhood was inundated with meth, and the driver's body language indicated he might have been on drugs. So, motion to suppress reversed. Florida versus Kraft, bunch of judges, bunch of different counties. You probably remember this. Kraft, the Patriots owner, was in a massage parlor and allegedly did things that are against the law there, and a bunch of other people were caught allegedly, and the trial court suppressed the hidden cameras in the massage parlors. It's kind of fact specific, so I don't know that you'll see something like this again. However, there's some really interesting quotes from the case about covert surveillance. In all the investigations, some innocent spa goers were video recorded and monitored, undressed, and those innocent clients potentially live with the knowledge that nude videos of themselves are preserved on a server somewhere with unknown accessibility. In our ever increasing digital world filled with hackers and the like, such awareness renders the surveillance a particularly severe infringement on privacy. This may apply to other scenarios, maybe some employment context. And then they said the type of law enforcement utilized in these cases was extreme. Quote, while there will be situations which may warrant the use of techniques at issue, the strict Fourth Amendment safeguards developed over the past few decades must be observed. If they are not, any evidence obtained could very well be declared inadmissible as a matter of constitutional law. To permit otherwise would yield unbridled discretion to agents of law enforcement and the government, the antithesis of the constitutional liberty of people to be secure against unreasonable searches and seizures. Covert video surveillance is subject to heightened standards, and so on and so forth. It's just some lofty, big statements in this case. Interesting. Okay, Moore versus State, Judge Siegel out of Broward County. This confession was deemed involuntary. When the officers were talking to the defendant, they never explained the limits on their authority to help appellant, the defendant, quoting from the case. The officers gave constant offers of unspecified help when they were requesting information from the appellant, and told him that the interviews was his only chance to come clean so that they could tell the judge about his cooperation. So if you are on either side of criminal defense practice, there are some really good data points here to analogize confession cases if you're trying to win a motion to suppress or defend it. Some very particular things that the Fourth DCA keyed in on determining that the confession was involuntary. I think unspecified help was the biggest thing I took away from it. Quarles versus State, Judge Furr out of Palm Beach, and the defendant's confession while in custody was not voluntary. This is one of these cases where they talk to the defendant and then they leave him alone, and then do they have to reread Miranda rights? And the Fourth DCA said the defendant should have been reread his Miranda rights after an hour. So a good case on if you have a defendant who speaks, is left alone, and then is spoken to again. Langle versus State, Judge Bellinger, St. Lucie. The Fourth DCA, this was a suppression of statements, and the Fourth DCA quotes a bunch of the transcript, which I have in here, but basically said that the trial court was right to suppress the statements, but suppressed it from the wrong point in time. At one point during the interview, the defendant said, "It's over, it's done." And then, everything after that was suppressed. And the Fourth DCA said, "Yeah, that's good, but you should have started suppressing it earlier on." And so before it got to the "it's over and done" point, the defendant said, "I don't know mine, and I have the right to representation." The Fourth DCA said, once that was said, "I have the right to representation," boom, he invoked his right to counsel. Nothing that came after that should have been allowed in. So again, some very specific language that you can key in on if you are on either side of a motion to suppress. Woodson versus State, Judge Bellinger out of St. Lucie. This is a sentencing issue. It's a very unique, in the weeds point of law, but quote, "The state can use a statement obtained in violation of Miranda at sentencing if the record shows the statement was voluntary and reliable." So you can use a statement that was the result of a Miranda violation at sentencing, provided that other factors are met. Valentine versus State, Judge Weiss out of Palm Beach. This was a lineup case, and there was a demarcation over the photograph. And the Fourth DCA found that the lineup was not unnecessarily suggestive, despite that demarcation. difficult case for me to get my head around, but in any event, the fourth DCA said the defendant's photograph was not the only one with the black bar above the photograph. The photograph in position 6 also had a black bar. So there were 2 with the demarcation. And nothing in the record suggests the manager's identification was influenced by the black bar. Rather, the manager testified he recognized the defendant as someone who had been in his store before and told the detective he was 100% sure. Anyway, it's tough case for me to get my head around, but in any event, there was a demarcation over the photograph, and apparently that was not unnecessarily suggestive. Some social media cases, and the reason why I call them social media is just things happened on social media that were interesting. I just try to create a cohesive category. First case is Pui versus State, and it's Judge Colbath out of Palm Beach. And there was a Snapchat by someone who said, "On my way, school shooter." And they filed a motion to dismiss saying, come on, this isn't the crime. This doesn't constitute a crime. No one thought, who thought this was real? I'm just saying on my way, I'm just joking. And the fourth DCA said, no, you cannot grant this motion to dismiss, quote, since there remained a material fact at issue, that being the interpretation of the posting. In this case, that interpretation should be made by a fact finder, not in a motion to dismiss, especially in today's world. Saying school shooter, this is the wrong choice of words, not funny at all. So they're going to have to get this resolved by a jury if they don't plea. That's what the fourth DCA found. Crapax versus Bacchus, Judge Moon out of Broward County. The trial court issued an injunction against this person regarding social media posts, and this was held to be unconstitutional. So the trial court's injunction prohibited this person from posting some names or any part of the names on any social media websites or internet websites, and then ordered this person to take down all social media and internet posts that reference these people or any part thereof. So it was like, don't ever say these people's names again, ever on any social media or anything close to saying these people's names. And anything you've said that's their names or anything close to their names, take it down. And the fourth DCA said, yeah, that's overbroad under the First Amendment. Another case that I have a hard time getting my head around, Logue versus Book. It's Judge Kaplan out of Broward County. There's a lot here, but the person seeking the injunction was a state senator, and the trial court granted the injunction and the fourth DCA overturned it. So apparently there was a proponent of an anti-sex offender law that was like harassing the state senator and was like saying things online and posted stuff about the senator's home online and did an online obscene song regarding the senator, depicted the senator dead in a cartoon, confronted the senator at a film festival, and protested the senator and the senator's father at a state capitol. All that happened, and the trial court's like, yeah, let's issue an injunction. Like, this is not good. And the fourth DCA said, no, it's okay. We shouldn't issue an injunction. Injunctions are not available to stop someone from uttering insults or falsehoods. Merely wishing someone ill health in a public forum without more cannot serve as the legal basis for an injunction. And then I'm quoting from the case again. Nothing in the First Amendment requires that constituents be kind or even polite in communications with or about their elected representatives and public officials. Its protections ensure the right of citizens in the body politic to dissent and express their opinions and desires, even in less than genteel ways on matters of public interest without the threat of prosecution, an injunction, or some other legal action. I got a tough time getting my head around this because posting about the senator's home online, depicting the senator dead in a cartoon, I think is a little, well, what do I know? I'm just a commentator, but anyway, that's no injunction here. It's a social media case. Okay, we're almost at an hour, so I'd like to take a 5-minute break and come back at 1 p.m. and we'll start the second half of cases. We made it about halfway through 100 cases. So I'll see you guys back here at 1 o'clock. You don't have to log out. I'm gonna shut down my screen for 5 minutes. Okay, everybody. Coming to you back for the second hour of a 2-hour CLE. If for whatever reason you're only joining for the second hour on the rebroadcast or live, just to recap, this is a Florida Bar approved CLE. It's a 2-credit hour. The number on your screen right there, that reference number, is what you'll need to plug into floridabar.org to get your credit. This CLE is being recorded right now and will be rebroadcasted. And this CLE covers significant opinions from the 4th DCA for the entire year 2020. I went through every single opinion, and I do summaries as part of my business. And then for the CLE, I went back through each of the summaries and tried to categorize about 100 cases in significant areas that I categorized. This is just my categorization. Some of the opinions are really long. There's hyperlinks to the cases. You can read the opinions yourself. But I tried to make sense of some of these opinions in groups. And there were over 700 opinions, written opinions, not PCAs, but I'm talking like actual written opinions. So we just spent an hour on about half of the cases. Now we're going to pick back up with the second half of cases. This is the category of criminal law. So the first case, State versus Cheeks. This is a horrible fact pattern. This person was, the victim was like sexually assaulted while jogging. Really, really bad fact pattern. And they like picked this person up and apparently didn't charge this person in enough time on the speedy trial rule. And the issue came down as to whether like the day the person was picked up, whether that was a functional arrest for the purposes of triggering speedy trial. Now, I think that because of how heinous the assault was, I think that might have had an impact on the analysis. But in any event, there was no functional arrest, even though the officers took this person into custody because, quote, the officers did not have an intent or a purpose to arrest the defendant, didn't communicate to him that he was arrested, and the evidence did not show that he thought he was arrested. The detectives testified that standard procedures require a person to be searched before being placed in a patrol car. So, and had this guy been arrested, he would have been taken to the jail. Instead, he was taken to police headquarters for questioning. So that's not arrest. It wasn't taken to the jail. While Cheeks was handcuffed, searched, and placed in a police vehicle and driven to the station for questioning, there was no evidence that the officers, either at the scene or at the police station, intended to arrest Cheeks that day. And then he said he never said he thought he was under arrest. Now, I just think that this crime should not go unpunished. But this is a very difficult analysis because they did take him into custody. But in any event, they said that's not an arrest. So it's not a functional arrest. Interesting case. Rodriguez versus State. This is Judge Timothy Bailey. If you saw the CLE a couple weeks ago on the fourth quarter of 4th DCA opinions, this was one of the cases that I covered there. And I thought it was significant enough to cover in the year review. So this defendant had wrecked a car and was rushed to the hospital, and the state attorney wanted, the hospital records, the EMS records, like everything, because he's driving a fast car. He must be under the influence. We want to, get his records to show that he was under the influence. And the 4th DCA said, no, that's not okay. You can't just get someone's medical records just because they got into a car crash. Quoting from the case, there must be some reasonable founded suspicion that alcohol or drugs were involved, such as someone smelling out alcohol, drug, or alcohol containers in the vehicle, or statements or evidence which might suggest drug use or alcohol intoxication. Here, there was nothing to suggest that. This is like bare suspicion. Just because he drove fast into wrecked his car doesn't mean he was drunk. I thought that was a very interesting case on the limits of states, subpoena, the state's ability to subpoena hospital records. I don't want to get too much in the weeds on blood draws and stuff, but it's a very interesting case. Say versus State. Judge Volker out of Palm Beach. There was a plea agreement that linked to federal prison sentence, and just quoting from the case, where a condition of a guilty plea is that the defendant will serve the agreed upon state sentence in federal prison concurrently with a longer federal sentence, the defendant is entitled to post-conviction relief if the terms of the agreement are not met. The violation of the plea agreement entitles appellant to relief, and the trial judge's statements to appellant after the plea had already been entered and accepted by the court did not change the terms of the bargain. So after the plea had been agreed to, whatever the judge said didn't matter. That was interesting. It's down there in the weeds on like 3.850 type motions, but it really does come down to what's on the transcript. But apparently after that plea's accepted, what the judge said doesn't matter. Okay, Harris versus State, Judge Timothy Bailey out of Broward County. There was a trial where the victim said that the ring was, quote, probably worth $3,000, and the 4th DCA said that's insufficient and speculative, and that cannot prove the value just because someone says this ring's probably worth that much money. For those of you who don't practice criminal law, the value of money can enhance the crime for a theft. So that's why it was significant here, but enhance the penalty for the crime. And so probably you can't establish worth based on probably. That's a good thing to have, and I think it would apply in the civil context as well. Schultz versus State, Judge Johnson out of Palm Beach. This was interesting. This motion to withdraw was not accepted, even though it just said irreconcilable differences. I think most motions to withdraw I've seen just say irreconcilable differences, and like, yeah, granted. But the 4th DCA said no, we need some specific reasons, such as whether the attorney-client relationship has deteriorated to a point where counsel can no longer give effective aid in the fair presentation of a defense. Now, timing might have been an issue, so that might change things, but I'll just read about the timing, quoting from the case. In this case, the motion to withdraw was filed on the eve of sentencing rather than on the eve of trial. Nevertheless, the same rationale applies, as permitting withdrawal at such a late juncture would have hindered the functioning of the court, as there would not have been time for appellant to procure new counsel. Appellant neither requested new counsel nor asked to proceed without counsel. So then they really, 4th DCA really went there. They went to the rules and said a motion to withdraw was legally insufficient as it made only a bare assertion of irreconcilable differences without providing any details as to the alleged conflict. A motion to withdraw must set forth reasons for withdrawal. See bar rule, or excuse me, see rule of judicial administration. Without such details, a court is unable to determine whether any of the grounds for withdrawal set forth in the bar rules are present. I mean, I just have never seen this in practice. So I wonder how this will play out. Anyway, this is very interesting to me. I mean, you say things about what happened, and then now you're violating attorney-client privilege. So very interesting decision to me. Quinn versus State. This is Judge Kastronakis out of Palm Beach. And this guy like broke a vase in a fight, and breaking the vase as a result of like a fight didn't support criminal mischief. It's a little bit of a silly proposition, but you have to have malice towards the vase to have criminal mischief. So just because he wanted to beat the person up and wanted to didn't mean to break the vase, didn't mean he, by extension, had malice toward the vase. The evidence proves only that the defendant acted with malice toward the victim, not the vase. He didn't have malice toward the vase. The victim's testimony was that the vase broke from the defendant is simply insufficient to support criminal mischief. So that's an interesting case. Some civil procedure cases. Izquierdo versus Del Valle, Judge Dale Cohen out of Broward County. and this is a modification of time-sharing case, and the fourth DCA said that the trial court should have allowed the mother an opportunity to amend the pleading. Kind of a generic standard, but helpful nonetheless. A claim should not be dismissed with prejudice without giving the plaintiff an opportunity to amend the defective pleading unless it is apparent that the pleading cannot be amended to state a cause of action. And so it wasn't apparent that the mother could not plead a substantial change in circumstances. If you deal with family law issues, this will resonate with you. Time sharing, substantial change in circumstances, you get a couple bites at the apple. Okay. Market Traders Institute versus Kent, Judge Kerner out of Palm Beach. And here the trial court was required to permit discovery on the venue issue and hold an evidentiary hearing on the motion transfer venue. So motion to transfer venue gets filed. You're required to get discovery and required to have an evidentiary hearing. I think that's a pretty great guarantee. In this case, stands directly for that proposition. You get discovery and you get an evidentiary hearing on your motion to transfer venue. Waldeck versus McDougall, Judge Lopane out of Broward County. You've probably seen like a lack of prosecution in different jurisdictions. They call it different things. I think FWAP in like in Miami, but in Broward, you'll get if like the case is dormant, you'll get a lack of prosecution notice. And the rule is that any record activity is okay. Has there been any record activity? So there was record activity, and it doesn't matter what it was, the case survives. It's a pretty neat opinion to read. I don't want to foreshadow too much because I'm getting to some opinions that have some great quotes, but quoting from the case, no record activity, no good cause shown at least 5 days prior to the hearing, case dismissed. Record activity shown within the 60-day grace period, case survives. Simple. So if you do anything in the grace period, you're okay for a lack of prosecution. Next case, Varchetti versus Varchetti, Judge Cox out of Indian River. It's a family law rule. So if you do family law, this would resonate with you, but the rule of procedure 1.061G doesn't provide a time limit for motions to dismiss for forum nonconvenience and family law cases. The family law rules do not contain any time limit for raising the issue of inconvenient forum under the Uniform Child Custody Jurisdiction and Enforcement Act. So you've got cross-jurisdictional stuff about child custody. The family law rules don't prescribe the time limits regarding inconvenient forum. Denton versus HSBC Bank, Judge Stone out of Broward County. This is about like affirmative defenses and replies. It may be specific to foreclosure cases, but a couple high points from this. I'll just read a couple quotes. Homeowner's affirmative defense alleged that she was prejudiced, and thus homeowner was required to prove her affirmative defense. Therefore, there was no requirement that the bank file a reply in avoidance. So some affirmative defenses require replies, others don't. The ones that bear, the affirmative defenses that bear a burden of proof on the person asserting the affirmative defense does not require a reply. So that's the point the fourth DCA was making, because the affirmative defense had a burden not on the bank. The bank didn't have to do a reply. So that's an applicable principle to other cases as well. Corman versus Stern, Judge Coates out of Palm Beach. There was a failure to serve process of the second amended complaint. They didn't serve process for the second amended complaint. The fourth DCA said, wait a second, why are you dismissing the complaint? Because they were already served, the first complaint was already served. So you didn't need to re-serve the second amended complaint. So I'm not sure I've seen that argument before, but here it is. You cannot get your case dismissed just because you didn't serve the second amended complaint, the first amended complaint. You're good if you serve the first complaint, because it sounds obvious, but once you serve the first complaint, you don't have to keep reserving the amendments. Okay, Berlin versus FDOT. There was an order granting a motion to strike a claim for attorney's fees, and that was reversed. And quoting from the case, because a motion to strike only tests the legal sufficiency of a claim, it is reversible error for a court to grant a motion to strike where the pleading presents a bona fide issue of fact that may be supported by evidence. The appellant's motion was legally sufficient to allege a claim for attorney's fees. So this motion for attorney's fees was legally sufficient. It's a bare bones motion citing the case to the statutes which authorized attorney's fees. So motion for attorney's fees, bare bones. It's four corners. It was legally sufficient. In moving to strike the motion for attorney's fees, the Department of Transportation raised an evidentiary issue, not a sufficiency. So the FDOT was like, well, they're not entitled to fees because, and so that we should strike it. And the fourth DCA said, no, you can't do that. The issue should not have been decided in a non-evidentiary hearing on a motion to strike. So motion to strike cannot raise evidentiary issues. Now, this is a whole sub issue, whether you can do motions to strike motions, but in any event, it's a good motion to strike case. And the reason why I say that is pleading. So there's a whole body of law that says motions are not pleadings. And then, is a motion for attorney's fees a pleading? I don't want to get into that, but in any event, that's why it's a little bit confusing, because some courts say motions are not pleadings, but here, this is a motion to strike, motion for attorney's fees, which they deem to be a pleading. I'm not sure that every court has found that motions are pleadings. Griffin versus Palm Beach Board of Commissioners, Judge Nutt out of Palm Beach. A person was rollerblading, fell into a hole. And the trial court granted summary judgment on a statute that the defendant did not plead in an affirmative defense. Quote, the failure to raise an affirmative defense prior to a plaintiff's motion for summary judgment constitutes a waiver of that defense. So they didn't raise the affirmative defense prior to the motion for summary judgment. That's a waiver. So red flag, get your affirmative defenses in there before summary judgment. And then the trial court also shouldn't have granted summary judgment when the plaintiff sought leave to amend to address this unpled statutory defense. So this is also a case about moving for leave to amend when summary judgment's filed. Plaintiff had not previously requested leave to amend. The privilege had not been abused, nor had there been any showing that an amendment would have prejudiced the county. Since the county had not filed the statute as an affirmative defense, the plaintiff had no opportunity to respond to it. So let them amend. Let them do their affirmative defense and let the plaintiff amend. Okay, Peterkin versus Geico, judges Tudor and Nutt, Judge Tudor out of Broward, Judge Nutt out of Palm Beach. There was a class certification case seeking a declaration that Geico's uninsured motorist coverage rejection process fails to comply with Florida law and does not properly advise policyholders regarding coverage options. So class certification was denied. And it's an interesting class certification case because this concept of standing must be determined before Rule 1.220's requirements are considered. That's the class action rule. That's an interesting principle because it appears that they're vectoring class certification to be about standing before we consider anything else. And as far as why class certification was properly denied, the fourth DCA said that the plaintiffs cannot establish commonality and typicality of claims. The class encompasses customers who purchased policies between 2010 and 2016, but but Geico's procedure changed a couple times during that time period. So, next case, Landquist versus Munyon. Judge Kiever Agrama out of Palm Beach, and party filed documents prior to the clerk's entry of default. and then a default was issued, and that default was void. It shouldn't have been issued. Quoting from the case, when a party against whom affirmative relief is sought has failed to file or serve any document in the action, the party seeking relief may have the clerk enter a default against the party failing to serve or file such document. But if the defendant filed any paper in the action, the clerk is not permitted to enter a default. What was interesting here was what was actually filed. In this case, the personal representative filed multiple documents before the clerk entered the default, including a designation of email address, a motion to withdraw as counsel, and an amended motion to withdraw as counsel. Other documents were filed, but one is sufficient. So if like a notice of designation is filed, that's enough to hold up a default under this rule, clerk's default. Some sanctions cases. There are a lot of sanctions cases. If you were there for the second DCA year in review, I spent some time on some sanctions cases. I'm doing that here too. And I guess the takeaway is sanctions get issued. So like it's courts are not a place to play around. Here are some sanctions cases. Ramos versus North Star Entertainment Firm, Judge Rodriguez out of Broward County. The fourth DCA reversed an order of direct criminal contempt and a sentence of 60 days in jail. This is a civil case, direct criminal contempt and 60 days in jail. The court had issued for a witness who committed perjury in a landlord-tenant dispute regarding documents that were allegedly submitted to FDLE. So let me just say this again, civil case, landlord-tenant, and like one of the parties went to jail for 60 days and was held in direct criminal contempt. Now the fourth DCA reversed it, saying, the trial court didn't provide the party an opportunity to be present and explain himself prior to finding him in contempt, and the court failed to strictly follow the procedures of the rule, and that failure would independently necessitate a reversal. This isn't a case where like the false statement is virtually undisputed. There may be some wiggle rooms. And as the documents on which the trial court relied in its conclusion were created out of the court's presence, and the Ramos did not admit that his testimony based on those documents was false, the court erred in finding him in direct criminal contempt. So the statements to the DBPR took place outside of the presence of the court and cannot be the basis of a direct criminal contempt. So apparently there's a lot of steps that need to happen in a situation like that, but goodness, it happened at the trial court level nonetheless. So interesting case. Okay, MB versus DCF, Judge Olafson, and the trial court entered a constructive consent to termination of parental rights against the father before he arrived 50 minutes late for his trial. And the fourth DCA said they shouldn't have done that as a sanction. The father was late because his car broke down the day before trial and he was unable to find a prompt ride the next morning. And the father made a reasonable effort to be present, and therefore the motion to vacate should have been granted. You shouldn't take away parental rights. He arrived 50 minutes late. Okay. Pompano Automotive versus Horgan, Judge Phillips out of Broward County. Not a lot in the actual opinion, but in any event, the party was allowed to seek an order enforcing the outstanding sanctions order for discovery violations before the trial court and seeking further sanctions for the prejudice caused by appellee's delay in moving to reopen the case. So discovery violations get you sanctions, and delay in moving to reopen a case can get you sanctioned. Joyce versus Shingary, Judge Roby out of Martin County. There was a sanction against the party because they didn't allege the right jurisdictional requirements. So like, yeah, you get sanctioned. You didn't say the right thing regarding jurisdiction. And the fourth DCA reversed, saying if the circuit court later determined it lacked jurisdiction, it could have just transferred the action to county court. Again, the takeaway here in all these cases, like the fourth DCA may not review the case, so courts don't have time to play around. And so I think this court was thinking the party was being cute by not alleging the right jurisdictional requirements. Fourth DCA said, don't sanction them, you should have just transferred it. But we as practitioners and people who are in the courtroom should be mindful that what you say matters, and courts do not have time for any games. Law offices of Fred Cohen versus HEC Cleaning, Judge Gillen, Palm Beach. This is interesting. The trial court granted a motion to strike 57-105 motion because they didn't do the e-service requirements under Florida Rule of Judicial Administration. And the fourth DCA reversed, saying that that rule, the e-service rule, doesn't apply to the safe harbor notice in a 57-105 motion. So safe harbor notice does not need to be sent in accordance with the e-service rules. That's interesting to me. It needs to be sent. Don't get me wrong, it needs to be sent, but not in accordance with the e-service rule. Okay, Ruffin versus Borga, Judge Lopane out of Broward County. Here, the trial court imposed attorney's fees as a sanction without notice and an opportunity to be heard. So we reverse and remand. So on the bright side, you got to have a notice and opportunity to be heard. But on the other side, this person got sanctioned without notice and opportunity to be heard. Maybe the fourth DCA is not there every time that happens. So again, it's another cautionary tale. State Farm versus Medina, Judge Rodriguez out of Broward County. The trial court should not have set aside a defense verdict given allegations of misconduct by the defense counsel and the defense's expert during trial. So as a sanction for what happened during trial and the defense's expert, the trial court just set aside the verdict. And this is what the expert said in front of the jury. I don't know if it's a question, but I'm not plaintiff's attorney. I don't give my opinions based on money. And that was super inflammatory. And the trial court just set aside the verdict because the defense expert said that. And the fourth DCA reversed, saying, well, while the comment may well have been blurted out in anger, the comment was elicited by plaintiff's attorney. Strem's Law Firm versus Avatar Property, Judge Rodriguez out of Broward County. There were sanctions in the form of attorney's fees against the lawyers, and they were reversed because they were not sought by the clients, and they were imposed without notice. So when appellants requested that the trial court consider a lesser sanction, the trial court instead imposed an additional sanction by requiring appellants to pay their clients, the lawyers to pay their clients, the amount the clients sought as damages in their lawsuit against the insurer. So the trial court sanctioned the lawyers and the amount to pay their clients, the amount the clients were seeking as damages in the lawsuit. And the fourth DCA reversed that and said the clients didn't seek an award of sanctions, nor did the trial court provide any notice that it intended to rely on its inherent authority to sanction. Because the trial court awarded relief not sought and without notice, it did not comply with due process. Again, cautionary tale. Fourth DCA has a lot of cases, so they reversed this one. Safeco Insurance Company of Illinois versus Haka, Judge Rodriguez out of Broward County. There was a 57-105 sanctions motion, and the trial court. I'll read the top line and I'll just repeat it in a different way. Quoting from the case, the trial court cannot award the movement not only the movement's reasonable attorney's fees, but also an additional punitive amount, such as the amount equivalent to the non-movement's attorney's fees. So the trial court got reversed, but the trial court had issued attorney's fees against the losing party to pay the other side's attorney's fees, and then increased that amount by what the losing party had paid, would have paid to their own attorneys. And the fourth DCA said, no, you can't stack it like that. It's just fee shifting one way. Don't double it up based on some additional punitive calculation. The seller versus Avatar Property and Casualty Insurance Company, Judge Blank out of Palm Beach. The insurer failed to establish by clear and convincing evidence that the insureds engaged in a scheme to defraud so as to warrant the extreme sanction of dismissal. So if you're dealing with like false affidavits or false statements, and you want to get a sanction of dismissal, you've got to get, quote, clear and convincing evidence. Here, there were some inconsistencies between the insured statements regarding the cause of damage that were not significant enough to warrant dismissal. The insureds apparently didn't have any plumbing expertise, but said some things about plumbing, and it wasn't really clear, where the cause of the water damage was. So they might have been over elaborating, but it wasn't like clear and convincing that they were trying to defraud the court. They were just speaking about plumbing stuff without really knowing what they were talking about. BB Inlet Property versus 920 Stanley Partners. Judge Gillen out of Palm Beach. This is, to me, a good result because it reinforces that courts really pay attention to spurious allegations. And this is a cautionary tale to not get too wide with a net about alleging things, upon information and belief. So here, both the party and the lawyers, the fourth DCA found that they should have been sanctioned for falsely alleging in a counterclaim that a dock was built with a fraudulently obtained permit. Yeah, and they built that dock with a fraudulently obtained permit. They put that in a counterclaim. And the fourth DCA said, no, you can't say something like that and not get sanctioned. If it's false. The inequitable conduct doctrine permits the award of attorney's fees where one party has exhibited egregious conduct or acted in bad faith. A trial court has inherent authority in imposing attorney's fees against an attorney. So what happened is they made it worse when they amended their counterclaim when this issue was brought up, and they said, well, it was either fraudulently obtained or it would have been fraudulently obtained. They did this like either or thing. And then they doubled, maybe quadrupled down on it and said, yeah, we're going to get discovery. We've got discovery. They agreed to an order allowing the people alleging that this thing was fraudulently obtained to produce the fraudulently obtained permit application, and they never produced the application. So they basically said they had it and they didn't have it. And there are no permits required to build docks anyway. So yeah, I like this case because it means the fourth DCA does not allow people to mess around saying things that just are not true. U.S. Bank versus Petrie, Judge Small out of Palm Beach. The trial court here should not have stricken the parties' discovery responses because they were, quote, signed by an attorney who had not filed his own separate notice of appearance than the already participating law firm. If you're going to strike some discovery responses, you got to have an evidentiary hearing on the issue. So on to some discovery cases. Mimedex Group versus Pairing, Judge Levinson out of Broward County. Simple statement, but the court departed from the essential requirements of the law in overruling the attorney-client privilege and work product objections without first conducting in-camera review. So work product, attorney-client privilege objections, in-camera review. There's some other DCAs are saying the same thing, but if you have these objections, the court has to do an in-camera review before ruling on attorney-client or work product objections. Otherwise, the court will get reversed. Citizens for Thoughtful Growth versus City of West Palm, Judge Kelly out of Palm Beach. Here, the trial court required this organization to reveal the identity and contact information and property addresses for all its members and supporters who would be adversely affected by the development order that this organization was challenging. Like, well, you're challenging this this development order. Turn over all the all your members, and we want to know where they live and who they are and how to contact them. And the fourth DCA said, no, that's not how it works. Simply because an association filed an action as plaintiffs didn't mean that the organization waived their privacy rights concerning members' names. you see members' names coming up sometimes in like condo type litigation. This may be a discrete issue here, organizational identity, but it may be applicable in some condo cases. MyPay Corporation versus JM Field Marketing, Judge Bidwell out of Broward County. Here, there's a web-based inventory management software program was a trade secret. So if you're looking for a good trade secret case, this case gives some good data points as to why and how intellectual property can be trade secret. Here, quoting from the case, each order and piece of paper can be traced back to a single inventory, and pending orders can be modified to reduce product prior to arrival. These features are unique and not well known or available on the market. Altogether, this makes the program a protected trade secret. So, and then another quote is, while MyPay may have owned the data input into the program, how that data was compiled and manipulated constituted the trade secret. So if I'm trying to establish that something's a trade secret, I would be looking at this case and I would be having the witnesses testify to how it's compiled and manipulated, what's unique about it, what's not well known in the market. It's really, really good stuff in here to establish trade secrets, and if you're trying to establish trade secrets. Or on the other hand, if you're opposing it, in the absence of these data points, I think you've got a better argument that it's not a trade secret. Some jurisdiction cases. AT&T versus SNS Utilities. Judge Matz out of Palm Beach. The trial court should not have found the arbitration provisions to be permissive, not mandatory, and this came down to the use of the word may. So quoting from the case, arbitration clauses are usually interpreted as mandatory, even if they use the permissive may, even if they say may, unless they require both parties to consent to arbitration or otherwise make clear that one party can opt for litigation over arbitration. So for me, the takeaway is just be really freaking clear in your arbitration provisions, because may and you could get into a problem. It's very surprising that the word may did not cause a problem. Now, if you read the opinion, there's like Texas law in there, so it's a little confusing. But in any event, this is, I think, a very good takeaway for other cases. Use of the word may doesn't mean it's a permissive arbitration clause, but if there's other language, you may, pardon the pun, get in trouble with the word may. Leibner versus Sider, Judge Hari out of Broward County, and here the trial court did not exercise jurisdiction over a claim for declaratory relief, finding that the amount in controversy didn't exceed the jurisdictional, or didn't meet the jurisdictional minimum or go outside of the county court's jurisdictional threshold. And the fourth DCA said that was error because circuit courts have concurrent jurisdiction in matters of equity, regardless of whether the amount in controversy exceeds the county's jurisdictional threshold. Matters of equity. So what did they allege? They sought declaratory relief, damages, and injunctive relief for violations of Consumer Collection Practices Act, some Deceptive Trade Practices Act, as well as damages and equitable relief. So it's an interesting case. As we all know, the jurisdictional limits increased this year. So, but apparently that doesn't matter in matters of equity. JH versus DCF, Judge Gam out of Broward County. Here, the trial court lacked statutory authority to both terminate jurisdiction and order the mother to complete a case plan. So just to be clear, like case over, jurisdiction done, but mom, you need to go complete a case plan. And the fourth DCA said, no, once the case is over, there's no jurisdiction to order the mom to do anything. Kaiser versus Only Moso USA Corp. Judge Robinson out of Broward County. And there, the trial court had no jurisdiction to enter an order setting a bond or a temporary injunction while there was a stay in effect pending appellate review. So if you had been at some of the other CLEs, this issue of bonds has come up in the DCAs this year. And apparently the party below was asking the trial court to fix a bond issue while the merits of the injunction were being litigated on appeal. And the fourth DCA said, no, you're stuck with whatever your trial record is on your bond while the appeal of the injunction is going on. Just to foreshadow, if you watch any of the other CLEs, you'll see a bunch of bond cases reversed because bond wasn't established. So that's what's significant about this case. You can't fix your bond problem if there's already an appeal of the injunction. Okay. Performance Air Mechanical versus Miller Construction Services. This is Judge Singal out of Broward County, who's now a United States District Court judge. And here, the party did not waive a contractual right to compel arbitration by answering the complaint and engaging in minimal discovery. If you've ever litigated motions to compel arbitration and waiver, there's generally like a giant string cite of cases on either side saying, oh, doing this and doing that and waiting this long is waiver, or doing this and doing that and waiting this long is not waiver. So this is one of the cases in the, I guess, ever-growing list of string cites tending towards no waiver, even answering a complaint and engaging in minimal discovery. It's a little surprising because a lot of the cases in the string cites you'll see say that answering and doing discovery actually does waive a right to compel arbitration. Surprising it didn't here. City of Hollywood versus Perrin, Judge Bowman out of Broward County, and the trial court lacked jurisdiction to order the parties to arbitrate. The employee filed a lawsuit to compel arbitration. This is a union case, so if you've ever dealt with this, you'll know what's going on here. If you haven't, you have to read the opinion, and it's a little in the weeds, but basically the employees' union had the exclusive right to arbitrate the grievance. Without question, the collective bargaining agreement grants the union exclusive authority to arbitrate issues of contract interpretation. The employee's grievance sought arbitration over an issue of contract interpretation. So this is, the union had the exclusive right to arbitrate. So here's a category called great quotes. And I just made this category because there were a ton of cases. This isn't all of them. When I was reading them, they were really fun to read, and they were just random great quotes. Not sure that all of them could be used in other contexts, but I thought I'd talk about them because they were just really cool. Azur Moore Investments versus Hoyen. This is Judge Robinson out of Broward County. And like I started reading this opinion, and it was like the witching hour was a special moment in the middle of the night when every child and grown up was in a deep, deep sleep. I mean, I was ready. It was like a novel. I got my popcorn. What's this case about? And it's about Rule 1.500B, but which is a boring rule, but an opinion made the rule not boring. So this is a story of missed deadlines on both sides, motions not properly set, and late answers, creating a real-life witching hour for the appellants, resulting in entry of default judgment against them after they filed an answer after a court deadline. So the court here got into, this is Judge Bokor, who's now on the third DCA. He was an associate judge. He wrote a couple opinions that were like this, and just a very simple ministerial interpretation of Rule 1.500B. And this is how the judge concludes, or the opinion concludes: a default can neither be entered as a ministerial matter by the clerk, nor can it spring into being automatically. The language of the rule clearly and unambiguously requires affirmative additional action by the court. Great quote. Another case, Key versus State, Judge Fine out of Broward County. This was about the rule of lenity and construing a statute, but then all of a sudden the opinion said, it's not unlike the old baseball axiom that the tie goes to the runner. That was fun. That's neat to read. Although there is no such rule in the baseball rule book, this axiom is frequently used by umpires to resolve close disputes as to whether a runner has been thrown out at first base. So the court analogized the rule of lenity to tie goes to the runner, and construing a statute is kind of like tie goes to the runner. And then if you're there's an aggravating circumstance provision of sentencing statutes, and the trial court incorrectly construed the statute according to the 4th DCA. Another case, TB versus DCF. This is Judge Meadows out of St. Lucie County. This opinion invoked Kafka. Just went right at it. One definition of the term Kafkaesque is having a nightmarishly complex, bizarre, or illogical quality, and then like does a dictionary cite of Kafka. This is the world of Appellant, and I do think it was the right analogy, because this father's parental rights were terminated because he, in following the case plan, he occasionally and arguably unavoidably came into contact with the children's mother, and that was prohibited, but he's following the case plan. So, he's illogical, it's a Kafkaesque problem. And although mere contact with the mother outside the presence of the children was not prohibited by the case plan. So it was an apt use of Kafkaesque, and it was neat to see that being used in a court opinion. Krzyzak versus Dawson, Judge Hames out of Broward County. Now, this quote, I think, could be used in a lot of different circumstances, like newly discovered evidence, new witnesses, late filed motions or whatever. The quote is, "Civil trials are not the Wild West where one side ambushes the other at trial." I think that's just such a great quote that I'm going to use next time someone tries to throw out new evidence in violation of a deadline or something. And here there was new evidence of PTSD, a PTSD diagnosis by a doctor that was not in the doctor's deposition. So this opinion of a PTSD diagnosis first revealed itself to the defendants on the eve of trial. And the plaintiff did not accept the trial court's tentative offer of a continuance, so the trial court crafted a ruling that limited the unfair prejudice imposed on the defendants while allowing much of the testimony to go forward. So the plaintiffs basically had the ability to just do a continuance and let this doctor be redeposed, and they didn't accept the continuance. They just sprung it on to the defendants, and the trial court did the right thing and made a limited ruling to prevent prejudice. And I think the plaintiffs were still complaining, and that's why the 4th DCA said civil trials are not the Wild West where one side ambushes the other at trial. Another case, State versus Daly, Judge Garcia Wood out of Broward. If you saw the CLE a couple weeks ago on the 4th quarter of the 4th DCA, you saw this case. This was a motion to suppress that was reversed. There was a be on the lookout, and the 4th DCA said, yeah, that be on the lookout was sufficiently particularized. The trial court didn't think so, and Judge Gross didn't think so in dissent, but the 4th DCA said, be on the lookout, identifying a burglary suspect as a black male, 5'11", wearing a gray hooded sweatshirt. That's enough. That's particularized. Judge Garcia Wood didn't think so, and she examined the evidence, and Judge Gross didn't think so and said, we should have left this up to Judge Garcia Wood and examining the evidence. So here's the great quote. Judge Gross says in his dissent, contrary to the law, the majority has reweighed the evidence. Reweighed the evidence. That's not the job of the 4th DCA. That was Judge Garcia Wood's job. Some changes in the law are momentous. Others, as in this case, come into the law like Carl Sandburg's fog on little cat feet. Cool quote. Okay, here's some miscellaneous cases. Campbell versus State. This is Judge Alspector out of Broward County. And here, the court reporter's missing transcript, didn't have a copy of the transcript, required reversal of the judgment and sentence and a remand for a new trial. So, sometimes you'll hear people joke in voir dire or the court to jurors, or just whenever, like say that the court reporter is the most important person in the room. And this is a case that shows why people say without the transcript, and even the state conceded this, quote, both Campbell and the state agree that an attempt to provide meaningful appellate review through other means did not succeed. They also agree that Campbell satisfied his threshold burden of demonstrating a basis for his claim that the missing transcript would reflect matters that prejudiced him. So we accept the state's concession that the judgment and sentence must be reversed because of the missing transcript and remand for a new trial. You know, this is why people say court reporters are super important, because they are. If you do not have a transcript, sometimes it requires a judgment and sentence being reversed and a new trial. And the state conceded it. Okay. Albra versus Senzi, Judge Kaplan out of Broward County. This is another, I put this next because this is another transcript case. Appellant failed to provide a transcript of the final hearing, without which we cannot determine whether the trial court erred. So sometimes clients are saying, why do you have to get a court reporter? This is why, because without a transcript, if something goes off the rails at a hearing, it's very difficult, if not impossible, to have the appellate court review what happened if it's not in the court record. There's no transcript. So this is a great case to show a client, if they're arguing with you about whether to pay for a transcript, this is why we do it. It's a safety mechanism, because something can happen and then you have no appellate remedy, because no transcript can't determine whether the trial court did anything wrong, or that no competent substantial evidence supports the judgment. And they even said, well, we don't need a transcript. The judge has made adverse rulings in the past, and no, that's not enough. We need to see exactly what happened in the transcript. Don't have it, no appeal. Cassidy versus State, Judge Caracuzo out of Palm Beach. This is about voir dire. The people were complaining that they weren't given enough time, and the Fourth DCA said there's no mathematical formula that determines how much time the trial court should allocate for voir dire. And that determination is left up to the judge and on a case-by-case basis. So he asked for 2 hours. He got 75 minutes. It's okay. Prime Investors versus the Meridian Companies. This is Judge Lopane out of Broward County. Here, summary judgment was reversed. I cited this case only because of this quote by the Fourth DCA, which seemed strange to me, but it's good instruction about what the Fourth DCA wants to see in summary judgment orders. Summary judgment was reversed. There was affirmative defense regarding construction liens and stuff, but the important part to me was this is the Fourth DCA speaking, we use this opportunity to strongly encourage circuit courts which are inclined to grant motions for summary judgment to provide their reasoning in some fashion. Now, obviously what's odd about that is that on appeal, it's de novo. So de novo means new, like it doesn't really matter what this trial court thought, because it's up to the Fourth DCA de novo, anew, to look at everything anew. But the Fourth DCA says, we know it's de novo, but knowing what the circuit court's reasoning is would be helpful to consider in reviewing the order. I mean, I think what they're saying is that it's not really de novo, but from a practitioner standpoint, is like the proposed orders you send in, make them detailed. You have a better chance on appeal. So not just summary judgment granted, let me just write that after the hearing really quick, take some time and cite some stuff, and you'll have a better time getting your order upheld on appeal. On the flip side, if you got hit with summary judgment on the other way and it's not very detailed, maybe this case would be helpful to you. But I don't know. I mean, I read this language a little differently than I think the way the Fourth DCA intended, because de novo means de novo, but they're saying it's not really de novo. So I have to read this a couple times to figure out exactly what they're saying, but the top line, make the summary judgment orders more fulsome. The Fourth DCA wants to see that. Ponomarenko versus Esanova, Judge Gunderson out of Broward County. And there was a motion for disqualification, and the trial court was within the trial court's discretion in limiting the amount of time the party had to try to disqualify the judge at a hearing. So apparently at the hearing, the party said, I need to disqualify you. and I need time to write a motion for disqualification, Judge. And the judge said, okay, do it right now. And I'll give you X amount of time. I can't remember in this opinion whether they said how much time the trial court gave, but that was okay, like time at a hearing. Now there was a case that they were citing to where a trial court gave someone 15 to 20 minutes to prepare for disqualification, and they tried to analogize their case to that case, but that case concerned some threats to the lawyer and some other stuff. But this is a interesting disqualification case. It's under miscellaneous, so I thought it was important enough to talk about, but not really widely applicable. Okay. Dick O'Neill versus Herman, Judge Hari out of Broward County. This is a great case. This is about unsworn statements and unauthenticated evidence. And apparently this person was saying things before they were sworn in as a witness. So statements were made while he was attempting to cross-examine the appraiser. He had like a pro se litigant. And the trial court relied on those statements before he was sworn in as a witness. And some of the quotes here, even if we were to accept that the circuit court in a non-jury trial involving a pro se party was willing to treat the borrower's oath as applying to the borrower's pre-oath statements, the borrower's statements nevertheless lacked any foundation as to their veracity. Sometimes people say a lot of stuff, like lawyers will make factual assertions or parties will make assertions that they're not sworn in. I think this is a really, 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 really good case to hone in on, like, what's under oath. You know, did that person make it under oath? Is a lawyer testifying, or are we having like actual evidence here? This is a good case to zero it in. Like, the court just cannot take into account unsworn testimony, and like, let's have a foundation. Let's have a record. So I think this is a great case for dealing with opponents that just pontificate a little too much, or have witnesses that pontificate not under oath. I'm speaking to like hearings where people start talking and no one's under oath. I mean, that, I don't know how frequently you guys see that, but I see that a lot. So trial court cannot take that as evidence. All right. That was about 100 cases, and we're right around the 2-hour mark. So this was a free 2-credit hour Florida bar approved CLE. And this number here on your screen is what you're going to need to do to get credit at floridabar.org. Put in that number and get your credit. This CLE covered about 100 out of over 700 opinions handed down by the 4th DCA in the year 2020. The demonstrative you have seen. If you're on Zoom, get it from the chat function. If you're watching this on rebroadcast, email me and I'll send it to you so you can go over the demonstrative. I think it's very helpful to look at the demonstrative. There are hyperlinks to the cases so you can read the cases on your own. The CLE was conducted by me, Colin O'Brien, and my company, the Florida DCA Wizard, which provides real-time case law updates of appellate court decisions. And there's some more free upcoming Florida bar approved CLEs. I'm doing the 3rd DCA year in review. That's 2 credit hours. That's January 15th, 2021, if you're interested in that. If you liked what you saw, a couple weeks ago, I did significant 4th DCA case law developments from the 4th quarter of 2020. I was mindful that people would be watching more than one CLE, so I only covered 2 of the same cases from this CLE, so it's not any repetition. And this CLE does a little more comparative analysis with other DCAs, whereas the CLE you just saw here was just 4th DCA. And then yesterday I did the 2nd DCA year in review. Both of those are on YouTube, and you can email me for a copy of the demonstrative if you want to watch those CLEs. They're free, and you get credit hours for them. If you want to contact me about other CLEs, please feel free, wizard@floridadcawizard.com. And if you're interested in subscribing to my service, it's pretty much what you saw here, which are bullet point summaries, and then a hyperlink to the case as the DCA decisions come out real time. It's $25 a month for one DCA, real time, $50 a month for every single DCA and the Florida Supreme Court real time. And if you want the entire year of summaries for any DCA, I could just email you all the summaries. You know, for the second DCA, it was over 500 opinions. For the fourth DCA, over 700 opinions, so on and so forth for the other DCAs, $250 per DCA. Thank you very much for your time, and I hope there was something that was helpful to you here. Have a happy new year.